Welcome to Supreme Law. We update regular videos to improve your knowledge. Don't forget to like and subscribe to my channel.
Yes, marital rape and rape are two different offences, and IPC 375 and 376 are different sections of the Indian Penal Code that deal with different aspects of sexual offences. Marital rape refers to non-consensual sexual intercourse between spouses, where one spouse forces the other to engage in sexual activity against their will. In India, there is currently no specific law that criminalizes marital rape. However, there have been calls to recognize it as a criminal offense and to amend the law to provide protection to victims of such acts. On the other hand, rape is a criminal offense that involves non-consensual sexual intercourse with another person. The offense can be committed by anyone, including a spouse or a partner, and is punishable under IPC Section 375. IPC Section 375 defines rape and prescribes punishment for it. IPC Section 376 deals with other forms of sexual offences, including rape of a minor, gang rape, and sexual assault. The section also prescribes different punishment for different offences, depending on the gravity of the offence. To summarize, while marital rape and rape are different offences, they both involve non-consensual sexual activity. IPC 375 and 376 are different sections of the IPC that deal with different aspects of sexual offences, and prescribe different punishments for different forms of sexual offences. Here are some of the notable cases and their judgments. State of Maharashtra v. Madhukanarayan Murdekar, 1991. This case was a landmark judgment by the Supreme Court of India that broadened the definition of rape to include non-penile/vaginal acts, such as oral sex and penetration by foreign objects. The court held that any non-consensual act of sexual gratification could be considered rape. Vishakha v. State of Rajasthan, 1997. This case was a landmark judgment by the Supreme Court that recognized sexual harassment at the workplace as a violation of the fundamental rights of women. The court laid down guidelines to prevent sexual harassment and created a framework for employers to deal with such complaints. Bhavari Devi case, 1995. Bhavari Devi was a social worker who was raped while performing her duties in a rural village in Rajasthan. The case led to the enactment of the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act, 2013. This case also highlighted the issue of caste-based discrimination and violence against women. Nirbhaya gang rape case, 2012. The brutal gang rape and murder of a young woman in Delhi in 2012 sparked widespread protests and led to changes in the criminal laws related to sexual offences. The case resulted in the amendment of the Indian Penal Code to include new offences such as acid attacks, stalking, and voyeurism. The accused were sentenced to death, which was later confirmed by the Supreme Court. Independent Thought v. Union of India, 2017. This case was a landmark judgment by the Supreme Court that declared the exception to the law on rape in the Indian Penal Code, which allowed for sexual intercourse with a girl between the ages of 15 and 18 if she was married, to be unconstitutional. The court held that such an exception went against the interests of the child.